Very good afternoon, friends. Today again we have come here to discuss further regarding the corporate social responsibility. Friends, in earlier classes we have discussed regarding some topics that origin and evolution of the CSR, its legal provision. Legal provision means which provisions shall be applicable for the corporate social responsibility, that is as per the Companies Act or any other law. And further in the next further class we will discuss regarding some definitions. And now we are going to today discuss here basically the responsibilities of the board of directors of the company in related to the company corporate social responsibility. So the main part is the function and responsibilities of the board. What shall be the function and what shall be the responsibilities of the board regarding the corporate social responsibility in a company? In this regard, it is here you will have to understand. We will understand the thing that as the board is the ultimate authority and authority, so the main responsibility and the ultimate responsibility lies on the board, the members of the board. So they have to ensure each and every compliances, whether the company is complying the provisions of the Companies Act or any other applicable provision, whether that is in corporate social responsibility or any other provisions. We are here only to discuss about the corporate social responsibility provisions. So we will discuss the functions and responsibilities of the board regarding the corporate social responsibility. What are the functions? So the mainly it is the responsibility of the board. It is the function of the board that the board that whether the CSR policy are being implemented or not. The board of the company shall be fully accountable and responsible for the execution and implementation of the CSR policy and all the projects that are formulated thereunder. The board shall ensure that whether the provisions of the resources for the establishment, implementation, maintenance and continual improvement of the system required for the CSR. Next is that whether involvement of all concerned stakeholders in CSR implementation are being ensured or not, it shall be ensured only by the board. Awareness and promotion of CSR as an integral part of the business and culture. Besides this, we have to understand that basically the board is responsible from the very starting of the CSR project to the level of completion. So during the period, whether the required provisions are being implemented or not, whether the proper CSR policy has been formulated or not, and whether it is being implemented, the ongoing projects, ongoing improvements are being ensured or not. So these all are the responsibility of the board. Further, CSR implementation is also provided under Rule 4 of the Company Social Responsibility, Corporate Social Responsibility Rules 2014. What this rule says, that the board shall ensure that CSR activities are undertaken by the company itself or through third party. So if any company is required to implement the CSR, so it can do itself or it can do it through the third party also. There are various companies, big corporates, which implements their CSR projects through the third party because their projects may be large and they don't want to involve their manpower in this project. Their ultimate goal is only to comply the provision and to ensure the benefits to be provided to the society of the society, to the person of the society. So a company can implement the CSR projects through itself or through third party. This through third party can be companies registered under Section 8 of the Companies Act. What are those Section 8 of the Companies Act? The company registered under Section 8 of the Companies are such companies which are incorporated only for the purpose of promotion and development of science, art, culture. Means it is not incorporated for the purpose of earning benefit, but it is for the purpose of growth of the society. It is for the purpose of benefit of the society. So it can, any company can implement the CSR project by itself or through third party, and that third party may be company registered under Section 8 company, or a registered public trust or a registered society, exempted under sub-clauses 4, 5, 6 or 6A of clause 23C of the Income Tax Act, Section 10 and Section 12A, and approved under Section 80G of the Income Tax Act 1960, established by the company either singly or along with any other company. So there may be one or more agencies, there may be the implementing agency, may be the company itself or third party. Besides this, a company established under Section 8 of the company, a registered trust or a registered society established by the central government or state government. It means the organization which is implementing the CSR projects, it may be the private organization, it may be the government organization. It may be in the form, it may be registered in the form of company under Section 8 of the Companies Act. It may be registered under the Indian Trust Act. It may be registered under the Society Registration Act. So these may be exempted under Section 10 and Section 12A of the Income Tax Act. It may be registered under Section 80G of the Income Tax Act. Any entity established under an act of parliament or a state legislature or a company established under Section 8, what we have discussed earlier. So company registered and the company registered under Section 8 of the Companies Act, or trust or society, it may be government, it may be private. So these may be implementing agency. Even the international organization can also be the implementing agency for the corporate social responsibility. Now we come to the mandatory registration of CSR entity. Every eligible company who intends to undertake any CSR activity shall register itself with central government by filing the form CSR1 electronically with the registrar with effect from the first day of April 2021. So there was a notification issued by the Ministry of Corporate Affairs that if any company is registering, if any company is doing CSR activities, whether mandatorily or voluntarily, in that case it will have to file form number CSR1 to the registrar of companies after 1st April 2021. And there shall be a unique number generated, that shall be the registration number for the corporate social responsibility for that company. That CSR form shall be certified by the practicing professional. That practicing professional will be chartered accountant, company secretary or cost and management accountant. International organization, company may, as I have discussed earlier, a company may engage international organization for designing, monitoring, implementing, evaluation of the CSR projects or programs as per CSR policy. A collaboration of other companies for CSR expenditure. Company may also do this. A company may also collaborate with other organizations, other companies for undertaking projects or programs of CSR activities in such a manner that CSR committees of the respective companies are in position to report separately on such projects or programs in accordance with these rules. CFO certification. The board of companies are satisfied that the funds so disbursed have been utilized for the purposes and in the manner as approved by it, and chief financial officers are certified to the effect. Ongoing projects. We have also discussed regarding the ongoing projects that ongoing projects can be of the multi-year projects but limited to for the 3 years. The board of companies shall monitor the implementation of the project with reference to the approved timelines, year-wise completion allocation, and shall be competent to make modification. Means if you have any project which is going to be implemented, which is going to take time for implementation for more than 1 year, in that case, what will you do? In that case, that project shall be called ongoing project, and the board of a company shall monitor the implementation of the project, because this is the main functions of the and responsibility of the board, that the CSR project to be monitored, whether to ensure its implementation, its execution. So the board of companies shall monitor the implementation of the project with reference to the approved timeliness. Means whatever the project was given, suppose the project was given for 2 years or 3 years, in such a case it will be calculated, it will be bifurcated that for what time what portion of the project will be executed. If any for a smooth, in case any modification is required, it shall also be done for a smooth implementation of the project within the overall permissible time period. Now implementing agency to be identified. This is also the responsibility of the board, that basically the board will not, the members of the board will not go to implement, to search the implementing agency. That will be done by the management of the company, but that shall be taken care by the board, that whether the implementing agencies are being properly selected or identified or not. So for the purpose of identification of the implementing agency, the following points may be considered. What is that? Should have track record of not less than 3 years, should not have any association with any political party, should not have any conflict of interest with the employees of the company or for the benefit to any of the employees of the company and their family members. Should have registration under section 12A of the Income Tax Act and section 80G of the Income Tax Act. From 1st April 2021 onwards, such agencies should also be registered with the MCA for undertaking CSR activity, that is filing of CSR 1 and registration number 2 be issued by Ministry of Corporate Affairs. Now CSR policy and action plan. What is CSR policy? We have discussed earlier also that the policy by which we will discuss, we will provide in detail that how the CSR activity will be undertaken, will be implemented. So this is the statement containing the approach and direction given by the board of company, taking into account the recommendation of its CSR committee, and includes guiding principles for selection, implementation and monitoring of activities, as well as formulation of annual action plan. Provision, we all know that what are the provisions. First of all, section 135 of the Companies Act 2013. Another is Schedule 7 of the Companies Act 2013 and Rule 2F of the CSR Rules 2014. All this CSR policy to be approved by the Board of Directors. Now, we can take a question that can a company spend in projects or programs related to activities mentioned in Schedule 7 to the Act but not specifically covered in CSR policy. Suppose that CSR committee has framed the CSR policy. It has got it approved from the Board of Directors. Now, it wants to contribute through CSR from by any such activity which is not mentioned in the CSR policy. Can it be done? But that CSR activity is mentioned under Schedule 7 of the Companies Act. So whether that can be considered as the CSR activity and compliance of the provision of the CSR. In such a case, what shall the company do? The company will modify the CSR policy and get it approved from the board, because whatever the activity is going to be done, whatever the projects is to be undertaken for the CSR purpose, that is obviously mentioned in the Schedule 7. So that shall be in compliance of the law. Only what the management will have to do, management will have to do the modification in the CSR policy and will have to get it approved from the Board of Directors. Is it mandatory to amend the CSR policy after amendments notified in CSR rules on 2nd January 2021? If existing CSR policy covers the following terms, CSR policy need not be amended. What are those? Approach and direction approved by the board based on recommendation of the CSR committee. Next is guiding principles for selection of CSR projects, programs, activities, implementation of CSR projects, programs, activities, selection, implementation, monitoring and of the activities, programs and plans, and formulation of the annual action plan. Otherwise, CSR policy need to be amended to include the above aspects. Now, what is annual action plan? Name denotes that what is the annual action plan. Annual action plan means what? That whatever action is to be taken during the whole year, that shall be called annual action plan. It can be, such plan can be formulated for any other activity. But now here we are discussing regarding the corporate social responsibility. So regarding corporate social responsibility, a company will have to formulate the annual action plan. It means what they are going to do during the whole year, during the whole financial year, that will be called annual action plan. In terms of the provision of Rule 5 Clause 2 of the CSR rules, The CSR committee shall formulate and recommend to the board an annual action plan in pursuance of its CSR policy, which shall specifically include the list of CSR projects or programs that are approved to be undertaken in areas or subjects specified in Schedule 7 of the Act, the manner of execution of such projects or programs, the modalities of utilization of funds and implementation schedules for the projects or programs, monitoring and reporting mechanisms for the projects or programs, and details of need and impact assessment, if any, for the projects undertaken by the company. So these should be included in the annual action plan. It is further also provided in that rule. What is provided? That the board may approve such plan at any time during the financial year as per the recommendation of its CSR committee based on reasonable justification to the effect. Means what are to be considered? First of all, who can do? Board can alter. Board can alter what? That plan. On what basis? On recommendation of the CSR committee. On what basis CSR committee will recommend? On the basis of the proper justification. What they will do? In the given case, if the CSR project will be completed and the amount of money left unutilized, what will we do? Be considered by the board for spending for other CSR projects. Activities after implementing the annual action plan accordingly. This fact should also be disclosed in CSR report. So what is to be done? Suppose that a company has formulated the annual action plan and it has budgeted a certain sum of money. For example, 20 lakhs or 2 crores. It has budgeted for 2 crore for the CSR activities and certain plans, certain activities. But at the end of the time or during the time or after the completion of those things, it has been noted that what CSR activities, whatever was formulated or considered for the annual action plan, has been implemented, but the money is still unspent. Whatever was the budget for the CSR activities. In such a case, what the board will do, the board will consider that amount, that unspent amount, and may allow for the expense for the other activities which shall be considered under the CSR. All CSR projects or activities are required to be approved in annual action plan. Otherwise, it requires the approval of CSR committee and the board with proper justification. You know why we have this is provided? Because if you will analyze the provision of the Act, that is section 135, what it says that this much amount, this much percentage of the net profit is required to be spent. What is that? That is 2% of the average turnover. So in the Act, it is not mentioned that what activities is to be done, but it is done that this much amount is to be spent for these activities. That is mentioned in the Schedule 7. So the main thing crux is that the particular amount which will be reached by calculating, that is 2% of the average profit of the previous 3 years. So that amount is to be spent. So in case that you have formulated annual action plan but the amount remains unspent, you have to spend that. The annual action plan shall change for each financial year and it is a manifestation of the guiding principle mentioned in the CSR policy. It is recommended that annual should clearly outline the mechanism and modalities for actual implementation of CSR projects. It is also recommended that annual should also speak about the expectation to be achieved during the next financial year. Now we come to the MCA clarifications. What are the MCA clarifications? Various clarifications was provided by the MCA because when the Act came into force, when this provision of the Act came into force, there were various ambiguities, there were various confusions. So in due course of time, MCA has clarified by issuing various clarifications from time to time. So first of all, by clarification issued by MCA on 18th June 2014, expenses for following activities not to be considered for CSR. What are those? One-off events such as marathons, awards, charitable contribution, advertisement, sponsorship of TV programs, etc. Expenses incurred by the company for fulfillment of any act, statute or regulations such as labor law, land acquisition act, because we will see that there are various provisions under the labor laws which are to be complied for the welfare of the laborers or workers. So in compliance of the act, whether that despite of the fact that this is for the benefit of the workers, it shall not be considered as CSR. Further clarification issued by MCA dated 28th March 2020. It is clarified that any contribution made to the PM CARES Fund shall qualify as CSR expenditure under the Companies Act 2013. You will see that in the year 2019-20, COVID pandemic was spread among the whole world. So in such a case, various contributions were made for the COVID pandemic. In such a case, the government decided to consider it as a CSR, which can help the country or the government to get more amount, and the companies will get the benefit of the CSR. Clarification on spending of CSR. For awareness and public outreach on COVID-19 vaccination programs, for setting up makeshift hospitals and temporary COVID care facilities, for creating health infrastructure for COVID care, establishment for medical oxygen generation and storage plants, for COVID-19 vaccination. These all were during the COVID pandemic because these were required, they were very much necessitated during the COVID period. So expenses on these facilities were considered as a CSR expenditure for the corporates. The companies may undertake their aforesaid activities subject to fulfillment of company CSR policy 2014 and the circulars related to CSR. Net profit, because we have also discussed under section 135, it is provided that 2% of the average profits, average net profit. So what is the net profit? Indian company, net profit of company as per its financial statement prepared in accordance with the Companies Act, but shall not include the following. What are those? Profit arising from any overseas branch or branches of the company, whether operated as separate company or otherwise, and any dividend. You must know that what is the meaning of the dividend. So any dividend from other companies in India which are covered under the complying with the provisions of section 135 of the Companies Act 2013. And foreign company, net profit means not profit of such company as a profit and loss account prepared in terms of clause A of section 1 of section 381 read with section 198 of the Act. CSR expenditure, rule 7 of the CSR rule 2014. We know that is also provided in the Companies Act that at least 2% of the average net profits of the company made during 3 immediately preceding financial year. In case company has not completed 3 years, in such a case, during such immediately preceding financial year, in pursuance of its CSR policy, this amount will be CSR expenditure. Preference shall be given to the local area and areas around it which it operates. So these are the provisions regarding the CSR expenditure and the basically action plan, basically the provisions, basically the responsibility of the board, or the responsibility of the board, annual action plan, and the regarding the COVID provisions. So these are all. In case you have any queries, you require any clarification, you can contact to us on our number 9720006036 and our email ID cc.pkja@gmail.com and on our YouTube channel, that is Corporate Concept Classes. So till then, with the hope that you have get all the clarification, whatever we have discussed here in a brief. Goodbye and thank you.